Hello, respected viewers. I'm Tort from Ireland. So this is an introduction to the English legal system and method. First of all, starting off with a question of what is the law? Well, law is obviously something which has the force of law, as in if you break it, penalties will follow. There could be civil penalties, there could be criminal penalties. A rule that's so important that it actually has to be passed by a legislature or indeed has evolved through legal decisions over the time. It's not just a rule in a private organisation, a rule inside a school, a rule inside a club or something like that, or inside a company. It's something that the state will back up with a state's authority, with courts, possibly police officers, and even prison, because we share this planet and therefore we seek to regulate behaviour. Certainly in common law countries, there's the harm principle. The idea you can do what you want so long as you don't harm another. However, what constitutes harm has broadened enormously in the past few decades. So what's the purpose of law? It's I suppose so society can function smoothly, to try to reduce the chance of people suffering, and to try to resolve disputes peaceably. So we have to regulate our conduct, so we can't kill each other unless absolutely unavoidable. We can't deprive each other of each other's possessions and so on. Then what constitutes an injury to another? As I say, the definition that's expanded. When you think about how you could be harming the environment, things like that. Because we drive, well, you can't just make it up yourself. Are you going to drive in the left or the right? Different jurisdictions have got different rules on that. So coming on to the English legal system, well, there's been an identifiable English legal system for well over a millennium. I mean, England was only mentioned about 735 AD, first of all, by the Venerable Bede. So England as a concept, as a word, is only a bit over 1,000 years old. And obviously the English legal system is not entirely original. It draws upon legal traditions that the Angles and the Saxons had in northwest Europe, to some extent the Romans as well. England has got a divided legal system into barristers and solicitors, and the common law countries follow that system. But Roman law countries usually don't have that. The United States is a big exception, being a common law country which has a united legal profession, only has lawyers. They sometimes call them attorneys. There's no distinction between barristers and solicitors. So there are several legal families around the world. Common law countries which I mentioned, and examples of this would be, say, Ghana or Tanzania. Singapore, Canada would be a huge example. Republic of Ireland, Malta, Cyprus, and India, for instance. And then there are Roman law systems, Roman law countries. We can sometimes say civil law countries, which is confusing. We don't mean civil in contradistinction to criminal. We mean civil as in Roman law, as in following Justinian's Corpus Juris Civilis. So this is a codified system, and they've got a set legal procedure which is rather stricter and more clearly defined than one finds in the Anglosphere. So they have written constitutions, usually, whereas the common law countries don't always. Judges don't make law there. They usually follow precedent, and they have constitutional courts which can strike down laws and so forth. So go back to common law. You'll find in common law countries, principally England. So common law is something which is justified by past practice, and that's as opposite to statute law. A statute is passed by a legislature. So a legislature is any lawmaking body, and a legislator is a member thereof. Westminster Parliament, that's the Parliament of the United Kingdom, is a legislature. The Welsh Senedd, also called the Welsh Parliament, is another. The Scottish Parliament, the Northern Ireland Assembly, and so forth. County councils, borough councils, and so forth, they're also legislatures. Common law and equity. Well, equity developed from perhaps the 12th century onwards, about conscience, about not allowing things which are unconscionable to be done. So sometimes there's a distinction between law and equity. I know it's terribly confusing because equity is type of law, but equity is not statute. All right, so there's public law and private law. So private law regulates how private parties, citizens or companies and so forth interact with each other. We sometimes say a natural person. Well, that's a human being to you and me. as opposed to something which has a legal personality. An organisation can have legal personality if it's capable of being represented in court. And there's public law, which regulates relations between the state and the citizen, or the state and other entities. So anyway, there's such a thing called judicial review, whereby governmental decisions can be examined, challenged in courts, and possibly struck down for various reasons. R against Lord Chancellor ex parte Witham 1997 is a leading case about that. And in this case, it was found that the Lord Chancellor, who was then the highest judge in the realm, had gone beyond his powers by removing a provision which said that people on modest incomes did not have to pay court fees to access the court. Now, the Divisional Court of the High Court found the Lord Chancellor had deprived people of their right to a fair trial. So, anyway, civil law is, as I say, there are no penal consequences. Nobody's going to prison for this one. Okay, whereas criminal law, well, this the state prosecutes. It's R against whoever. R meaning regina, as in the queen in Latin. So in the days when there was a king, it was rex, as in the king. Okay, so what's the standard of proof difference between civil law and criminal law? So criminal law, when you could possibly go to prison, in the old days, you could get the rope. You prove beyond all reasonable doubt. So there could be a penumbra of doubt, and nonetheless you could be convicted. Whereas in civil law, it's on the balance of probabilities, which is more likely. So the court will go whatever proven beyond 50%. Whereas in criminal law, a numerical expression of beyond reasonable doubt is thought to be unhelpful. Therefore, they say it's a decision which does not need to be revisited. Okay. Contract law is about civil law. There are agreements which are legally binding on the parties who sign them, and this is to deal with all sorts of transactions such as selling goods, land services, employment contracts, and so forth. Part of civil law is the law of tort. Tort comes from the French word tort, T-O-R-T. I remember when I was a teenager, first heard tort. I thought, what, the past tense of teach? No, forgive my risky pronunciation. Accent, it's tort, because and my accent's on rhotic. If the R is not word initial, it's merely vestigial in RP pronunciation. Anyhow, so if someone has done something wrong to you, committed civil wrong against you, you can take action against them. There's been negligence, there's been careless behaviour. If someone's defamed you by slandering you, saying something bogus about you, which will bring you to disrepute, then you could take legal action against them for that tort of defamation. Family law is also an area of tort, so divorce, child custody, and so forth, divvying up family property. There's also land law, as I say, about buying and selling land with buildings on it or without. So there's a difference between civil and criminal law. There's the adversarial approach in common law systems. Common law and civil law, I'm distinguishing between them. In common law systems, you have the two sides knocking seven bells out of each other. The lawyers, so they're adversaries, almost like they're enemies. They're courteous ones, and there's a judge who's there to be a referee in that rough game. And evidence is presented, witnesses are cross-examined. If the defence is allowed to cross-examine a witness, the other side is allowed to cross-examine a witness. You can't be cross-examined by just one side, and you can decline to give evidence. So ideally there'd be parity in the quality of lawyers, but often that's not true. And can you win if you're in the wrong just because you hire an expensive lawyer? Probably yes. Otherwise, why would people bother stumping up huge fees? Anyway, in civil law jurisdictions, it's an inquisitorial system. They inquire. It's an inquisition seeking to find the truth, and the judge will have a role in this. And the judge shall decide which witnesses are called. He takes responsibility for finding out the facts and so forth. So judges investigate in France in particular, and they question witnesses sometimes. So the prosecution and defence are not entitled to cross-examine. A lot of it in France is settled before the court date with an exchange of documents, writing back and forth. I knew about a case in Chad, actually, a francophone country. They follow the Roman law system as an erstwhile French colony, and documents were flying back and forth for years. And so that rather than and just had the courtroom date as a sort of climax, whereas they're battling it out in court in common law countries from quite an early stage. So it's about, the difference between the two systems about initiating the action, about amassing the evidence, and setting this sequence of events in terms of proceedings. So there's a legal method to be followed by lawyers and judges. So this is a way that you think and argue about the law. We need legal reasoning, therefore. Special sort of reasoning is needed for every academic discipline, and jurisprudence is no exception. So certainly in common law countries, judges have to follow precedents. They go along with earlier legal decisions to make things reasonably predictable. Now, as you may know, on the 23rd of June, in the year of grace, some 2016, the United Kingdom held a referendum on withdrawing from the European Union. 52% of people voted to leave the European Union. Hooray! Sorry, I'm not giving away my opinion on that one. Anyhow, so the European Union Withdrawal Act was passed in 2020. It became law on the 23rd of January that same year, and on the last day of January 2020, the United Kingdom left the EU. There's an implementation period, right? So EU is still applicable in the United Kingdom under the terms of the withdrawal agreement. So EU law is still a source of law in the UK. However, it can be abolished piecemeal. So it looks like the UK government's going to repeal it. But the assumption is it's all there. Even Brexiteers usually don't want to throw the baby out with the bathwater. There's some perfectly serviceable, sensible, and eminently sage legislation. So they're not gonna repeal it all, en bloc. So bit by bit, it might be got rid of. But the assumption is to stay there unless each bit is specifically appealed. All right, so that's just a very brief introduction to the English legal system. Toodle pip.